Hi, welcome to the Lauterpact Center for International Law.
So my name is Sarah Nouwen. I'm a fellow of Pembroke College. I'm a senior lecturer in law at the Faculty of Law in Cambridge, and I'm also a co-deputy director of the Lauterpact Center for International Law. So my research on international law adopts an external perspective. I mostly focus on the encounter with international law, and mostly in situations of conflict, and mostly in Africa. And this fascination with the encounter with international law stems from the fact that when I worked in Africa, usually in capacities other than that of an international lawyer, I was somewhat surprised by my own field. When studying international law in the Netherlands, a country that prides itself on hosting the legal capital in the world, I was imbued with the sense that international law is a force for peace, a force for justice. But when I worked on the African continent as an advisor, as a diplomat, as an NGO researcher, I was sometimes surprised by international law in the sense that the encounter with international law really challenged some of those assumptions that I had been imbued with about international law during my studies. Yes, of course. So during my research in Uganda and Sudan on the impact of the International Criminal Court on domestic legal systems, I observed how international criminal justice pursued one type of justice, criminal accountability for allegedly the greatest perpetrators of some international crimes. But I also noted not only that it of course has huge difficulties in achieving that objective, but also how it seems to marginalize other conceptions of justice. And those other conceptions of justice were very often much higher on the priority list of the populations most affected by the conflict. Examples are justice in the sense of law and order, justice in the sense of restorative justice, focusing on the restoration of the victim to the position he or she had prior to the commission of the crimes or prior to the conflict breaking out. And distributive justice, justice in the sense of distributing not just resources, but also opportunities within a country, but also across the world. So what I noticed was that international criminal justice may be a force for peace and justice in one sense, but actually may also be seen as undermining other conceptions of peace, other conceptions of justice at the same time. Oh, those experiences strongly shaped my research agenda. Indeed, I would say that my current research agenda is entirely inspired by those experiences. For instance, my current research project on the role of international norms in peace negotiations is entirely based upon my experiences as a participant and as an observer of peace negotiations in Uganda and Sudan. Oh, practical issues and field research are the starting point of my research. So it was during field work that I discovered how mediators and other external actors invoke international norms to influence what goes into a peace agreement, what doesn't go into a peace agreement, and to shape the process of negotiations. So on the basis of that empirical observation, I then try to speak to international law and to political theory. Oh well, the world of international law is all about norms. So international law consists of norms, consists of law, of obligations. But I intentionally use the word norms rather than law or obligations because it's a broader concept. And by looking at norms rather than these narrower phenomena, that allows me also to study the impact, the normative impact of phenomena such as best practices, guidelines, soft law, international standards, phenomena that are not necessarily or that do not meet the criteria of international law, but that can have huge normative impact. And I want to include that impact in my research as well. So that's about the world of international law. Now, and then you mentioned how does it work with, or what's the role in peace negotiations? Now that's exactly the question of my current research program. So what I'm trying to investigate is whether, when and how international norms in the broadest sense are invoked in peace negotiations, by whom, when are they invoked and when not, and what is the impact of that invocation on the peace process.